Greetings and welcome to the Women's Voices in Business podcast, a presentation of the Private Corporate Counsel Program at CPLS-PA. My name is Mary Kogut-Lowell. I'm a business lawyer and the director of the Private Corporate Counsel Program. In today's podcast, we're going to discuss another important issue for businesses, intellectual property or IP. First, we'll talk about what IP is and why it's important for businesses. We'll discuss the main IP rights and legal protection of IP rights. We'll also discuss issues that may arise as you manage your business intellectual property. Before we get started, though, I'd like to provide a brief overview of the Private Corporate Counsel Program. Private Corporate Counsel is a business development program that enables entrepreneurs and executives to access legal counsel and much more. Our mission is to help entrepreneurs and executives make the progress necessary to achieve their personal, professional, and business aspirations, get in the prime of their lives, and help their businesses grow and develop into market leaders. And with that, let's get started talking about intellectual property. First of all, what is intellectual property? I looked around for some definitions, and I came across one that I thought was pretty good. It's in a Florida Bar consumer pamphlet. So according to the Florida Bar consumer pamphlet, IP is the body of law that protects fruits of human intelligence. I like that, fruits of human intelligence. Inventions, creative works, and logos and brand names that we adopt for goods and services. I also saw a definition that I like from the World Intellectual Property Association. And according to that association, intellectual property refers to creations of the mind, such as inventions, literary or artistic works, designs, symbols, names, and images used in commerce. So I like that. IP refers to creations of the mind or the fruits. It's protection for fruits of human intelligence. And IP rights are often very valuable for businesses. For that reason, business owners are encouraged to understand and protect their IP rights. Business owners should also take care not to infringe on the IP rights of others. Let me give you an example. Recently, one of my colleagues told me about a client who had created a business and invested substantial sums of money on its corporate name, using it not only on website and letterhead, but they also substantially invested money in advertising. Unfortunately, that client had failed to check whether the name was registered in the United States Patent and Trademark Office in Washington, and we're going to talk more about registrations later. After operating about 5 years, this client was contacted by another company that had previously registered the same name in the U.S. Patent and Trademark Office. Ultimately, the client had to change its name, so all that money and time it invested, basically it was for naught, and they had to start again with a new name and building a new brand. So let's keep that in mind. Intellectual property is important. It's expensive, and it can be costly if you infringe upon the rights of others. So we've talked about what is intellectual property and why is this important. Now let's say what are the main IP rights in the United States? The main IP rights are trademarks, copyrights, patents, and trade secrets. So I've identified 4 IP rights, and let's define each of those 4 IP rights. Number 1, what is a trademark? Trademarks are source identifiers. And if there's any phrase I'd like you to take away from this presentation today, remember that trademarks are source identifiers. They help consumers identify the person or company responsible for the products they buy. And types of protectable trademarks include words, logos, symbols, and designs. Think, for example, of Coca-Cola. You say the name Coca-Cola, you know exactly what I'm talking about. Kentucky Fried Chicken, or KFC, you know what I'm talking about. That's because these are source identifiers. Consumers know the source of that those products come from a particular company. I also want to mention something today. I'll be referring to trademarks and service marks. A lot of people use the term trademark to refer to both trademarks and service marks, but they really are two separate things. A trademark is used to identify the source of a product and distinguish it from competitors' products. And again, I'll mention Coca-Cola. That's a trademark. A service mark is a mark to identify the source of services rather than products. Example, United Airlines. This is a service mark because United provides a service, which is airline transportation. So again, there is a distinction between trademarks and service marks, but collectively we often refer to them as trademarks. And how to protect a trademark or a service mark, the best way is to register it. It can be registered either in Florida or in most states where you may be operating, or with the United States Patent and Trademark Office. And after we define these four terms, we're going to talk more about the registration procedure. So that's number one, trademark. Number two, copyright. What is a copyright? It's the right to or ownership of the original expression of an idea in a fixed medium. So it's the original expression of an idea in a fixed medium. The copyright belongs exclusively to its owner. Examples: literary works, musical works, dramatic works, movies, sound recordings, architectural drawings. These are all things. So if I decided today that I love IP so much, I want to write my own book about intellectual property law, as soon as I write that book, I own the copyright in that book. But the best way to protect a copyright, again, is to register it. Now, this is registered in a different office in Washington, the U.S. Copyright Office, and again, when we get to protection, we'll talk more about the registration procedure. The third type of intellectual property is patent. A patent is the right to ownership of a new, unique, and useful invention. The invention must be a functional device or process. So, as you can imagine, if I invent some sort of new machine, or if I improve on a current invention, let's say I was the person who invented HDTV, an improvement of a current invention is something that can be patented. So a patent is a right to a new, unique, and useful invention. And finally, what is a trade secret? Any confidential business information that provides a business a competitive edge and is unknown to others may be protected as a trade secret. Okay, what does that mean? Well, think about KFC's secret recipe blend of 11 herbs and spices. That is a closely guarded trade secret. It's confidential business information that provides KFC a competitive advantage and is unknown to others. So that's what a trade secret is. Some other examples: Google has a search algorithm that I understand they continuously change and update, but that's a very closely guarded secret by Google. Or the formula for Coca-Cola, or McDonald's Big Mac special sauce. These are all confidential trade secrets. Now, there's protection under federal and state laws, but unlike the other IP that I mentioned, there is no registration procedure. Let's move up on to how to protect intellectual property, starting with trademarks. In the United States, trademarks are protected under federal law, and as I mentioned, owners can obtain federal registrations for their trademarks in the USPTO. And a federal registration provides the owner of that trademark rights throughout the United States. Trademarks are also protected under state statutory and common law. So I can register a trademark in Florida, but that only provides protection in the state of Florida. You acquire common law rights whenever you use a trademark in commerce, but the best way to protect it is by registering, and you need to pay a fee, of course, to register. Now, if possible, trademarks should be federally registered, as federal registration provides the registrant with several advantages. And let's think back to that example I mentioned at the beginning of this podcast. The client who invested substantial sums of money in a mark didn't know that someone had already federally registered the trademark and had to change the name. So federal registration puts people on notice, basically, that you own that trademark. So trademark's not required, but it definitely is encouraged. So let's suppose you have a name in mind for your business. And so you might ask yourself, is this a name that I can get trademark registration for? So let's talk about what kind of marks can be registered. First of all, the mark has to be distinctive, and I'll tell you more about what that means. And it has to be used in commerce. Remember, trademarks are source identifiers, so you have to use that trademark in commerce so that it can be associated with your goods or services. So let's talk about different kinds of terms and are they eligible for registration. Generally, you can't register a mark that's generic for the words, goods or services that you sell. What does that mean? Let's say I want to sell soap. I can't trademark the name soap. Or I want to sell a car. I can't trademark the name car because that's just a generic word for my goods. So generally you can't register a generic word. Another type of trademark are descriptive words. These can be difficult, but they can be difficult to register, but sometimes they are registrable. Example, soft and creamy for facial tissues, or creamy for sour cream. That's a descriptive term. It might be difficult to register. Now let's talk about a term, another kind of mark, arbitrary terms. Those are terms that are known. You can find them in the dictionary, but they're used in a way that does not describe the product or service. So it's an arbitrary term. We're not talking about using car for cars or soap for soap. Think Apple. Apple being is a very valuable trademark for the Apple company, but it's associated with the sale of computers and cell phones, not with Apple. So that's what we mean by an arbitrary term. It's a word you can find in the dictionary, but it's used in a way that doesn't describe your products that you're selling. The easiest kinds of terms to get trademarks are what we call fanciful marks. Those are words you won't find in the dictionary. A good example is Xerox. Xerox was a made-up trade name that only had connection with copy machines. So that's what we call fanciful works. Fanciful marks are usually pretty easier to register. One big issue in trademark registrations is likelihood of confusion, because you can have a term that you want to trademark, but if it's likely to be confused with another registrant's products or services, you're not going to get trademark registration. Example, let's say I want to start a chain of fast food stores and I want to call it McDonald's, M-A-C, capital D. That's too similar to McDonald's. There's a likelihood of confusion. So I wouldn't be able to register McDonald's for fast foods. Another example, let's say I want to sell some t-shirts and I call my company the Hanes Company, H-A-I-N-E-S. Well, it's spelled differently than Hanes, but there's a likelihood of confusion, so I wouldn't be able to register that. And likelihood of confusion, that whole principle applies to designs or logos as well. So again, that's the kind of words that can be registered. The owner has to pay a registration fee, of course, and it's more expensive to register your mark in in the USPTO, United States Patent and Trademark Office, than it is here in Florida. But as I mentioned before, national registrations or federal registrations are recommended, because registering a mark only in Florida would only protect you in Florida. And before moving on to copyrights, I want to mention something else about designations. And when I use the term designation in connection with trademarks, I'm talking about the little circle with an R in it. Owners of federally registered marks should always use that little circle R designation, because that helps put people on notice that your trademark is registered. But if you don't have a registered trademark, you can also use something called the TM designation. It's just the small TM, and that puts people on notice also that you are claiming rights to that mark. And finally, in terms of trademarks, be aware that the United States Patent and Trademark Office does have a searchable online database. So if you're thinking of a particular word you want to use, you might want to search there. If that client I mentioned in the beginning, if that client had searched the federal trademark base, perhaps it would have known that the name that it wanted to use was already in use. And Florida also has a searchable trademark database. So that's how to protect trademarks. Now let's talk about protection of copyrights, which again, that's an original expression of an idea in a fixed medium. So again, think of, let's say I write my book on intellectual property. That's an original expression of an idea in a fixed medium. Legally, I automatically, if I create that work, I automatically have rights to it. But I don't have to register it, but definitely registration has advantages, because, for example, copyrighted works must be registered before you can bring an infringement action in court. So again, when you have a copyright in something, a literary work, dramatic work, a musical work, you have that copyright. But if you ever want to sue anybody for infringement, you definitely need to have it registered. So registration also helps put people on notice that you own it. So it's a good idea for a lot of reasons, although it's not required. And let's talk about the designation for copyrights. You've perhaps seen the little C in a circle, followed by a year and then the name. That puts folks on notice that you're claiming a copyright in something, and unlike that R designation for trademarks, that's only for registered trademarks. You can use the small C designation whether your copyright is registered or not. And again, it's a good idea because it does put folks on notice that you are claiming ownership rights to that. So we've talked about trademarks, copyrights. Now let's talk about patents. In the United States, patents are obtained by filing an application in the United States Patent and Trademark Office in Washington. What's different about patents is there's no patent right until you actually get a registration. That's different from trademarks, because remember I mentioned that you get trademark protection by using a mark in commerce, and I own a copyright as soon as I make a creative work that's in a fixed medium. It's different for patents. You can have an invention, but you don't have, there's no common law. Common law refers to the body of law in our court cases. There's no common law protection. So if you invent something that you want to have registered, again, you do need to register that patent to own the patent. Now, of course, I've mentioned there are always fees for registration. The USPTO does give some reduced fees for what they call small entities. And then they have another class of businesses they call micro entities. So it's a small entity plus some other qualifications. So you can get a reduction in the patent fees if you have a small entity or micro entity. And there are other application fees that you have to pay. And also, I've mentioned in connection with trademarks, the USPTO has a searchable online database. It also has a searchable online database of patents. But, Again, the databases are helpful, but they don't always tell the whole story because, for example, patent applications are generally published 18 months after the priority date. So those are the registration. Somebody may have an application pending that you may not be able to find in that. And that's why it's, it's pretty important to do some additional work if you're really researching patents. Now, in terms of a designation, articles made or sold under a U.S. patent should be marked with the word patent, U.S. patent, or the abbreviation PAT, period, followed by the assigned number. Once again, this helps put people on notice that you're claiming ownership of that particular invention. So the final kind of IP we'll talk about in terms of protection would be trade secrets. So once again, trade secret, it's confidential information if it's not known, generally not known or ascertainable. It has to be secret. The party claiming the trade secret derives some sort of economic value or business advantage, and the party takes reasonable efforts to preserve the information secrecy. So again, if we think in terms of KFC and the secret recipe, it's not generally known. KFC definitely derives an economic value or business advantage by keeping that information secret, and KFC makes reasonable efforts to preserve that information secrecy. Trade secrets are protected at the federal level. There's federal law, and also all states except for New York and the District of Columbia have adopted a version of the Uniform Trade Secret Act. So Florida has adopted something called the Florida Uniform Trade Secret Act that provides ways that a victim of trade secret or misappropriation can use to calculate damages. Now, unlike the other forms of IP, there's no particular registration. There is no registration procedure for trade secrets. Nor is there a legal notice that must be attached. However, the owner should mark all trade secrets as secret or confidential and must be able to show an effort to preserve secrecy. So if you want to ever enforce your rights to trade secrets in court, you do have to show that you kept the information secret, and so a good idea is to keep it secret and show a reasonable effort to preserve secrecy. So those are the kinds of IP rights in the U.S. We've also talked about protecting IP. Finally, today, I'd like to talk a little bit about managing IP because there are a few issues that come up for your business as you're managing IP. And I'd like to talk about specifically two of those issues. One is creation of IP by employees or consultants, and secondly, infringements. Now, if you have employees or consultants or independent contractors, these people may create IP in the course of their employment or in connection with their independent contractor agreement. Therefore, employers should always, if you have employees who are going to be creating IP and you want to claim that for the business, the employer should have a written agreement with the employee specifying that all work product that's intellectual property is owned by the employer. It should specifically provide that copyrightable work is a work made for hire under the Copyright Act. And the Copyright Act has something called a work made for hire, which the federal statute specifically provides that if you have a contract with an employee where the employee is creating copyrightable work, it can be a work made for hire, but you need to have a contract to make that clear. This contract should also assign to the employer any work product that doesn't qualify as a work for hire, and also ensure that the employee must cooperate to secure and protect the employer's IP rights. And this does come up from time to time. I've seen that. In fact, many years ago, when Eastern Airlines was still in business, I defended a copyright infringement act that was brought by a former independent contractor of the company who claimed that when Eastern Airlines published a history of Eastern Airlines. They had a book called From the Captain to the Colonel. This individual sued Eastern Airlines, claiming that he had been hired as an independent contractor to prepare a history of Eastern Airlines, and this book used a lot of his work. So there was an issue there as to whether it was a work made for hire. So this does come up from time to time. The best way to protect against that kind of problem is to have a contract with the employee. And similarly, you should have a written contract with any independent contractors who are preparing intellectual property, so that you're sure that, or you can claim that intellectual property for your business. And finally, let's talk about avoiding infringement. And by that I mean you want to protect against other parties infringing your intellectual property, and you want to minimize the risk of your company infringing the intellectual property rights of others. So, there are various things you can do basically to protect against other people infringing their IP. It's good to keep an eye on competitors' products and make an informed decision as to whether another company is using your IP. So that's something to think about. And definitely, to minimize the risk of committing infringement owned by others, you can periodically train your employees and have guidelines aimed at avoiding IP infringement. But again, let's get back to that company I mentioned in the beginning. Simply checking those databases, checking the database, the USTPO database, Googling names. Before you decide on a name, go ahead and Google it and see if somebody else is using that name in connection with particular names and services. So it's really important to be careful to avoid infringing. Well, I hope you enjoyed our discussion today about intellectual property. We've discussed what IP is and why it's important for businesses. We defined the main IP rights in the United States. We talked about how to protect the IP rights for your business. And finally, we talked about a couple of issues that may arise as you manage your business's IP. And please continue listening to our podcast. Future topics will include employment discrimination laws, entertainment laws, and other topics of interest to business owners. Finally, to learn more about the Private Corporate Counsel Program and to see how we can help you and your business on your journey to success, please contact us at 877-647-7887, or you can email us at info@privatecorporatecounsel.com. Thank you very much for joining us. See you the next time. Please continue listening to our podcast to learn more. Contact us at 877-647-7887 or email us at info@privatecorporatecounsel.com to learn more about the Private Corporate Counsel Program and how we can help you and your business on your journey to success.